So let's talk about when constitutional rights collide in a criminal trial. When a defendant's Sixth Amendment right to call witnesses in his favor, to compel the testimony of witnesses who could be helpful to him, when those rights collide with the witness's Fifth Amendment right against self-incrimination. How do courts resolve that battle of the constitutional rights? Let's do a quick Team Justice Law School class, because justice matters. Hey all, Glenn Kirshner here. So in the Derek Chauvin trial for the murder of George Floyd, we now have a battle of constitutional rights. And I could talk for about an hour on this topic, but I'm going to try to boil it down to just a few minutes, and I'm going to try to hit the highlights, the big ticket issues that I think we're going to hear about in the coming days. So as of right now, Derek Chauvin's lawyer wants to subpoena a witness by the name of Maurise Hall, and he wants to present the testimony of Maurise Hall in Chauvin's defense, and Chauvin has a right to present witnesses in his defense. Maurise Hall, we've heard some evidence, may have provided drugs to George Floyd. So Maurise Hall's lawyer says, no, my client's invoking his Fifth Amendment right against self-incrimination. He can't be forced to testify because he would incriminate himself. So here is the origin of the two constitutional rights that are now in conflict. So Derek Chauvin has a Sixth Amendment right to, among other things, a speedy trial, a public trial, an impartial jury, a right to confront and cross-examine witnesses against him, a right to counsel. And importantly, for this discussion, the Sixth Amendment reads as follows: in all prosecutions, the accused shall enjoy the right to have compulsory process for obtaining witnesses in his favor. So basically, defendants have a right to compel, to force, to subpoena witnesses to come in and testify in his defense if they have something helpful to say. That's Derek Chauvin's Sixth Amendment right. How about Maurise Hall's Fifth Amendment right? Well, the Fifth Amendment reads in part, no person shall be compelled in any criminal case to be a witness against himself. And that protects witnesses who are compelled to testify, subpoenaed to testify, not just defendants. Defendants also have a right against self-incrimination. They don't have to testify, and they can't be forced to testify at their own trial. So how might the judge work it out? Well, there are a few options. The first thing that I would expect a judge to do, and I think it's exactly what Judge Cahill has done, he told the parties, see if you can work it out. See if you can narrow the scope of his testimony, narrow the questions that each side might want to ask Maurise Hall to see if you can avoid the incriminating stuff. Well, I predict that's not going to happen. It's not going to work, though. I think it's a good first step for Judge Cahill to say, let's see if the parties can work this out. Here's one of the concerns. Not only might Maurise Hall have a Fifth Amendment right against self-incrimination for drug dealing, but the laws of Minnesota say if you provide somebody drugs and they die, you might be on the hook for murder. So let's set aside all that conjures up in the George Floyd trial. And let's go right to the next possibility. The next possibility, if the parties can't work it out, could be what's called a stipulation of expected testimony. What does that mean? A stipulation is just an agreement between the parties. A stipulation of expected testimony is if the parties can get together and say, okay, if Maurise Hall was called as a witness to testify, if he didn't have to worry about his Fifth Amendment right against self-incrimination, here are the things he would say. He would say A, B, C, D, and E on direct examination. He would say, F, E, F, G, H, I, J, K on cross-examination. And here's his expected testimony. So that way, You can provide the information to the jury, but Maurise Hall doesn't have to come in, be placed under oath, and incriminate himself. Rather, that information would pass through his defense attorney and would be drafted up into a stipulation of expected testimony. I also don't think that one's going to work. What would the next possibility be? Well, it's been reported that both the prosecutors and the defense have subpoenaed Maurise Hall. So if they really both want to present his testimony, I'm not so sure the prosecution does. I'm not so sure the defense does. I'll talk about that in a minute. A lot of tactical gamesmanship going on here, in my opinion. But if the prosecution really wants to put Maurise Hall on the stand, they can do it. You know how? All they have to do is grant him immunity. Because if you grant a witness immunity, it extinguishes, it does away with that witness's right against self-incrimination. Why? Because by granting a witness immunity, you are saying, as the prosecutor, your words cannot and will not be held against you. So you don't have a privilege against self-incrimination. So if the prosecution really wanted to force Maurise Hall to the stand as a witness, they could simply grant him immunity. I haven't heard that they announced that they would do that. Let's assume the prosecution really doesn't want to put Maurise Hall on because he's going to be more helpful to Derek Chauvin, to his defense, than he would be to the prosecution. So then there's a tough decision to make. And you'll have to excuse me because this is a really short semester. I can't spin out all of the possibilities in just a few minutes. First of all, judges cannot grant immunity. Only prosecutors can grant immunity. So I've seen some questions come in on social media. Why can't the judge just grant immunity? Well, that's a prosecutorial decision and function. It's a separation of powers thing. The judiciary can't just give witnesses or potential defendants immunity. Only the prosecutors can. So if the prosecution doesn't want to grant Maurise Hall immunity, but the judge decides Maurise Hall's testimony is really important to Derek Chauvin's defense, and let's face it, judges are in the business of protecting a defendant's right to a fair trial, including making sure a defendant can compel witnesses to testify in his favor, as the Sixth Amendment guarantees every defendant can do. Here is what I would call the nuclear option. Here's what Judge Cahill could do. He could say, okay, prosecution, you don't want to give immunity to Maurise Hall. And there are many legitimate reasons a prosecutor wouldn't want to immunize a witness just to have him testify in favor of the defense. One, maybe they think the witness is going to lie, and you don't want to immunize a witness just to facilitate that witness telling a bunch of lies that might help the defendant. Another reason is the prosecutors might affirmatively want to prosecute Maurise Hall for his drug crimes. Not likely, but they could retain a prosecutorial interest. Another reason not to immunize Maurise Hall. But here's the nuclear option. I hope you're still with me. I know this is a little bit down in the criminal law, criminal procedure weeds. The judge could say, I find that Derek Chauvin's Sixth Amendment right to call witnesses in his favor is so weighty, is so important with respect to what Maurise Hall would testify to, that I'm going to abate the proceedings. I'm going to basically pause the trial until the prosecution finds a way to deal with Maurise Hall's Fifth Amendment right against self-incrimination, to extinguish it somehow, so then Maurise Hall can be made available to testify in Derek Chauvin's defense. That's the nuclear option, because no prosecutor wants his or her trial paused, for any significant amount of time. But the prosecutor, if push comes to shove and the judge says, listen, I'm here to give Derek Chauvin a fair trial, as despicable and horrific as his conduct was, every defendant is guaranteed a right to a fair trial. And as prosecutors, frankly, we have a responsibility to make sure those constitutional rights are honored on behalf of every defendant. So the prosecutor could try to enter into a plea agreement with Maurise Hall. I'll tell you what, Maurise, you plead guilty to drug possession, a probation-eligible offense. All of your Fifth Amendment right against self-incrimination, your rights will be extinguished by virtue of that plea agreement, and you can testify on behalf of Derek Chauvin. Or they could finally, the prosecutors could finally break down and just immunize, just give immunity to Maurise Hall so he could be called as a witness by Chauvin in his defense. And let me add a footnote, just because you immunize somebody doesn't mean you can't prosecute them later, but if you immunize them, you have a really high burden to prove that nothing the person said under the grant of immunity ever made its way into a subsequent trial against that witness. Think Oliver North. That's what squirreled his conviction ultimately. His case got thrown out because of his immunized testimony before Congress. Okay, that was not a short answer. That was a short semester, but it wasn't a particularly short answer. And here's what I'll leave you with. The thing that I think the prosecutors really want to avoid is building an error into this case that, in the event of conviction, it could be a winning issue on appeal for Derek Chauvin if the appellate court believes that Derek Chauvin was wrongfully denied his Sixth Amendment right to compel the testimony of Maurise Hall. I left a lot of questions unanswered, and there are a lot of additional twists and turns and permutations, so I'm sorry I couldn't cover it all. As this issue unfolds, I'll circle back to it when I see what Judge Cahill does and how the parties deal with this Maurise Hall issue, and it will probably be the subject of future videos. So in the meantime, folks, thank you for tuning in to this Team Justice Law School class. If you want to get involved in Team Justice more formally, or if you want to support our all-volunteer efforts here to put out these videos, including these tutorials, every day, then you can go over to patreon.com. You can sign up to become a patron, and you can more formally support our all-volunteer efforts. If you do sign up on patreon.com, I'll send you some Team Justice stickers and a personal handwritten note of thanks. But in the meantime, folks, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.